Good evening, friends. I, on behalf of Beyond Law CLC, welcome you all to yet another webinar on, as we have said already, that the entire pursuit during these times is that we should get ourselves enriched with knowledge through speakers who can give us insights which invariably large number of people would be knowing, but the deeper knowledge in the law as a student, as a common man or a lawyer or a judicial officer does help if you have a more flip. Because they say that the knowledge, the extra knowledge makes sure the extraordinary, the difference between the ordinary and the extraordinary is that extra effort. In that pursuit, today we have the topic of law of wills, probate, administration, and effect of nominations. In a lighter vein, they say that where there is a will, there is always a will. And where there is a will, there are also relatives. So, at least relatives we might not see, but with Mr. P.B.Balaji, a renowned lawyer on the civil side, who has been giving webinars as well as also giving his insights in the academies, shows that the will is not attracting, but the willpower to listen to the good people for the insights is always heartening and also motivates that too on a working day. Mr. Balaji, is it audible? Because someone is.
Yes.
Okay. Then you will have to check on your side as to whether it's audible or not, the person who is written. He's also co-author of the book on Tamil Nadu Building, Lease and Rent Development Act. So much so, when we were looking in pursuit to have the knowledge, large number of people told me that his knowledge. Can everyone post it, because large number of people are saying that it's not audible. It's audible. So as they say that testing times, like sometimes the password or some other issues do develop with a flux of time, but that is the willpower to continue to pursue and do better. So both the wills are always a source of attraction to move forward for anyone in the life. And what are the wills on the legal aspects and perspectives? We would request Mr. P.B.Balaji, advocate, to give the insights on this aspects. Over to you, Mr. Balaji.
Very good evening to one and all. Thank you, Mr. Vikas. And I would like to slightly tweak what you said in the later vein. Not only relatives, you have lawyers also. Where there's a will, we have lawyers and lawsuits too. I'm audible?
Yeah. To that only I will say that a doctor was asked when there was a lot of illness, etc. going on. He said that doctor, nowadays people are quite unwell. Even we can relate with this COVID-19. He said, yes, healthy times are going on. Over to you.
Thank you, Mr. Vikas, for the kind words. Very good evening to one and all. In fact, I should congratulate Mr. Vikas and his team, CLC team, for the wonderful series of lectures. I've been following them, and the lawyers are known to be giving free advice, but nowadays we give free advice too through these webinars. So it's interesting that the information is passed on to the general public, law students, advocates who may not be well versed in this particular subject. So it's a wonderful effort on part of CLC, and I think we should all congratulate them. So moving to the subject, wills, the most simple document, a simple legal document which can create a hell lot of complications to one and all, to the person who writes the will, his relatives, the beneficiaries. So that is why a will is very important. What is a will? You may ask me, what is a will? We all know that a will is a declaration of a person's intentions, which he desires to be carried out after his lifetime. So that is the very special characteristic of a will. A will, as distinguished from any other transfer of property, inter vivos, is that it postpones the enjoyment of the property and takes effect only after the lifetime of the maker of the will. So this is a very special characteristic. Another special characteristic is it is revocable. You can revoke a will, write another will, you can modify, alter. So this revocable feature is again a very important characteristic of will. Yet another very feature which stands out is you can cover properties which are not currently owned by you in a will. You can cover properties, your future acquisitions can be part of your will today. That is a very special characteristic of a will. And as you all know, wills are coming under the Indian Succession Act of 1925. This legislation was brought about even when the British regime was in force in India, and the act has not been amended substantially except for very few amendments subsequently, which I will narrate a little later. So the 1925 Act has come to play, and it has been enforced, governing execution of wills, proof of wills. All these are matters which will come under the Indian Succession Act of 1925. Before that, we had the Hindu Wills Act, which was superseded by the 1925 Indian Succession Act. The Indian Succession Act does not apply to Muslims. And at the inception, it was applicable to Christians also. But subsequently, by an amendment in 2002, the wills executed by Indian Christians have also been exempted from the provisions of the Indian Succession Act. So now, as on date, the wills which are made by Hindus, Jains, Buddhists, and Parsis will come under the provisions of the Indian Succession Act. So who can write a will? So we have seen what are the characteristics of a will. I'm giving a brief narration before straight away I don't want to go to probate and administration and nomination, because there may be persons who would like to know the fundamentals also. Therefore, briefly I will take you about what are the characteristics of a will, what is probate, what is administration, and before I take you to nominations. So will, who can write a will? In India, any person who is aged over 18 years can execute his will. He must be of sound mind. So that is the most important condition for a person to write a will. He must be of sound mind. He must be over 18 years. He can execute a will. As I told you earlier, there is no specific form for writing a will. No stamp paper is required. An ordinary white piece of paper, will can be written. The only requirement is 2 witnesses should attest the document, and execution and proof will come a little later. There are different types of wills. Broadly, if we are able to categorize wills, I would say unprivileged wills and privileged wills. Privileged wills are wills which are applicable to persons in actual warfare, in the Navy or the Army. They are given a special status. They can even make oral wills. They can write wills, need not sign them. So there are special benefits given to persons who are working for the country, the borders, and risking their lives. So a special provision is made called privileged wills for them. We do not come across privileged wills very often. What we come across very often is unprivileged wills. Unprivileged wills are what we have to discuss today. Unprivileged wills are, again, you can categorize into a number of wills. One is called a holograph will. A holograph will is a very important will because it is in the handwriting of the person writing the will. That is called a holograph will. And the weightage given to such a will by the courts in the event of any dispute later on is extra. Therefore, a holograph will is very important. A person who writes his will in his own handwriting is called a holograph will. We have joint wills, where 2 persons come together and write joint wills. We have mutual wills. We have conditional wills. We have international wills, living wills. So these are various kinds of wills which we'll come across. And when is it required to probate a will? So I will now come to probate. A person dies. As I told you, the will comes into effect only after the lifetime of the person who writes it. So he can choose to cancel the will, modify, alter, or execute a fresh will also. Or he can choose to do nothing, just cancel his will, choose to do nothing, the law of succession will take over. Therefore, will take effect after the lifetime of the maker. So therefore, the death of the person who writes the will opens the will. Until then, the will is only a mere piece of paper and does not have any actual legal sanctity. And when does probate come into play? What is probate? Probate is defined under the Indian Succession Act, and it says a certified copy of the will with power to administer the estate is granted to the executor. That is called a probate. It is a document which authorizes the person named as the executor in the will to administer the estate of the deceased, and a copy certified, duly certified to be the true copy of the original will is issued to such executor, and this is called a probate. There may be wills where an executor may not be named. There are a lot of questions asked, can we still get probate? Probate is always only to the named executor in the will. So if the will is silent about an executor being named, or the testator does not name an executor in the will, then we have to apply for letters of administration. That is what we call administration right. So probate is different, administration is different. Administration again is of two kinds. Administration with a will, administration without a will. So where a person dies leaving a will but does not name an executor, then you will have to apply for letters of administration with the will. Where the person dies without a will, for example, there are no class 1 legal heirs. Legal heirs are only brothers, sisters, or uncles' children, or whatever, class 2, class 3 legal heirs. In such case, the person's legatees can approach the court and claim for letters of administration without a will. So these are the categories of administration. You may ask me, what is the difference between administration and succession certificate? The succession certificate is in respect of only movable assets. Where a person dies without a will, you can approach the High Court or the District Court and seek for a grant of a succession certificate to deal with the movable assets. But where the person dies leaving behind immovable properties and movable properties, your remedy is to apply for a letters of administration without a will if there is no will. If there is a will, there is no difficulty. You approach for letters of administration with will. The will names an executor. You apply for probate. So this is the legal parlance of the three terms: probate, letters of administration, and succession certificate. So what is the effect of probate? Probate is a judgment in rem. It binds the entire world. Why wills are very important? Why courts attach so much importance to wills? You may ask me. The person who writes the will is no more. So the courts have always said the will is a very solemn document because it sets out a person's last wishes, how his hard-earned properties and money should be taken after his lifetime. So therefore, the courts have always said the will probate court is a court of conscience. That is why they want to give effect to the last wishes of the person who is no more. He has left behind some wishes. So the court does not want the wishes to be unfulfilled. Therefore, much importance and significance is attached to a will left behind by a person. In fact, wills are not new to the courts in India. Even in the 1920s, we have had litigation pertaining to wills. Matters have went up to the Privy Council, and even in the late 1950s, matters have been taken up to the Supreme Court after the Constitution of the Supreme Court. You will see a number of cases pertaining to wills. As I told you, an ordinary piece of paper can be a will, but it can create havoc when it comes to implementation. That is why you will have to be very careful in writing the will. Ensure that the execution is properly done as required by law, and so that proof of that will later on, when you are not alive, is going to be easy, and the beneficiaries will definitely take effect. The beneficiaries will take full effect of the bequest made under the will. So that is the importance of executing a will properly. So as I told you, judgment in rem, it binds the entire world. So courts have been very, very, I should say, they're not suspicious, but very careful in granting probate, especially when there is suspicion raised. When a person who claims to be a legal heir is not given the property under the will and he puts forth certain objections, if the court finds that the objections are suspicious in nature, the burden is very heavy on the person who sets up the will. He is called a propounder. The propounder has to dispel all suspicious circumstances before he gets a probate. Where do you go and apply for a probate? See, the Indian Succession Act contemplates filing of a probate petition or an administration petition before the district judge or the High Court. Section 300 of the Indian Succession Act gives concurrent jurisdiction to the district court and the High Court. So if suppose, for example, the property is in Bombay or Madras or Chennai, you have an option to go either to the High Court or the district court. But this exception is only available to 3 cities: Calcutta, Madras, and Bombay. because 302, section 302 specifically mentions that these three high courts will have concurrent jurisdiction with the district court concerned. In all other cases, it is for the government, the respective state governments, to pass a notification, a special notification, and confer concurrent jurisdiction on the respective high courts. Therefore, as of now, only three cities, namely the Madras High Court, the Bombay High Court, and the Calcutta High Court, have concurrent jurisdiction, and you can file a petition for probate or letters of administration either before the High Court or before the district judge. In all other places, wherever the state governments have not passed any notification, you will have to go only before the district judge and seek for probate. Probate proceedings may be contentious, non-contentious. Here, as you know, the Indian Succession Act is basically carved out from the English laws. We were governed by the British government, and more laws were framed, the Indian Contract Act. You see, number of laws, we have followed only the British legal system, the British jurisprudence is being followed. So similarly, in England, there was called a common form. Probate used to be given in a common form or a solemn form. In the common form, it is given for the mere asking. A person approaches the court and says, here there is a will, give me probate. The courts in England used to give probate in a common form. But in India, as a practice, as well as lack of statutory backing, it is always a solemn form. Probate is granted in the Indian courts only in a solemn form. Solemn form means it is in the presence of the interested parties and subject to proof and satisfaction of the court that the will has been genuinely made by the person concerned and that it is the last will of such person, because there may be a rival claim setting up a later will. That is why we call it a last will and testament. The last will always prevail. Here again, one important feature which stands out in a will is, suppose there is contradiction in two portions in the same will. The earlier portion says something, but the later portion of the will, there is a contradiction. Does not mean what was said in the first page. The later portion will prevail. Unlike a conveyance, a sale deed, where the first part will prevail. In case of contradiction in a sale deed or any other conveyance under the Transfer of Property Act, a contradiction, in case there is a contradiction in the document, the first statement will prevail. But whereas in the will, the later part, the later sentence will prevail. The later clause will prevail. This again is another important feature of wills. And so coming to solemn form, as I told you, in India, we have to apply only for probate in solemn form. The courts grant probate in solemn forms. You have to issue notice to all interested parties. So suppose all of them give their consent. They do not object. It is called non-contentious proceedings. So therefore, everybody, all children give their consent. Mother, the wife of the deceased is the propounder. The children are cited as respondents. They give their no objection. It is called a non-contentious proceeding. Simple. You just have to prove the will, examine one of the attesting witnesses. And what is required to be proved is the factum of death. As I told you, the will becomes operational only on the demise of the person. Therefore, the first requirement will be to prove the death of the person by filing the death certificate. Number two will be the fact that he left behind a will.
Mr. Balaji, probably you will have to go slightly slow. I just realized it because
sure. The will, so first proof is the proof of death of the person. Once you prove that a person is dead, the will comes into play. So second requirement is that the will is genuine. It is the last will and testament of that person, and it was executed by him in a sound and disposing state of mind, memory, and understanding. So how do you prove that? That is where the role of the witnesses is very crucial. Minimum 2 witnesses must attest the will. We have to fall back on section 68 of the Indian Succession Act, and the Evidence Act also comes into play, where it is very clear that you will have to, the will has to be attested by a minimum of 2 persons. 2 persons, how is the execution to be made? So the persons must see the testator sign the will. So that is the first requirement. Both the witnesses must see the person signing the will. They must confirm that he was in a sound and disposing state of mind, memory, and understanding, capable of understanding what he was executing or signing. That is the first requirement. Second requirement is the person who writes the will, who is called the testator, he must see the attesting witnesses attest the will. So this part is forgotten in number of cases. Both parts have to be proved. Proof of will requires not only proof that the attesting witnesses signed in the presence of the testator, but also that the witnesses signed in the presence of the testator. This is another important requirement. There may be very strange cases where will may have been executed in the presence of only one witness. The second witness is not available, but still the law gives an option. The testator can call, maybe even the next day, he can call the second attesting witness and tell the second attesting witness that I have signed this will yesterday in the presence of Mr. Vikas. Therefore, you please attest this as the second attesting witness. So if a personal acknowledgement is given by the testator to the second attesting witness, it is lawful and acceptable for another witness, the second witness, to sign at a different time. Not necessary that both witnesses should be present at the same time. It is preferable. It is advisable to have two witnesses at the same time so that there is no confusion. But if at all there is some emergency where you are able to procure only one witness for execution of the attestation of the will, you can always call the second attesting witness at a later point of time in the same day or the next day or a couple of days later. The only requirement is you will have to give a personal acknowledgement that this is my signature. This is the will I executed yesterday, day before yesterday, in the presence of Mr. Vikas. I request you to please attest. If the second attesting witness, Mr. Vikas, signs or signs in the presence of the testator, it completes due execution. So that is one leverage given for proper execution of a will. So not necessary that both witnesses should be present at the same time, though it is advisable, as I told you. And this is where there may be cases of contentious proceedings. A probate petition is filed, a legal heir, a son or a daughter is deprived of the property by the father or mother. So he is disheartened. He feels that the will would not have been executed by his father or mother. So he can file a caveat and object to the grant of probate by the district court or the high court. Once an objection is taken, the proceedings will have to be converted as a suit. And like a regular civil suit, the propounder who sets up the will become the plaintiff, and the caveator who sets up a defense questioning the genuineness of the will become the defendant. And the will have to be proved in the presence of the defendant. If the defendant raises any particular circumstances which dispels the possibility of truth or genuineness in the will, that burden also lies on the propounder. He has to dispel all circumstances which have been set up or pleaded by way of defense by the defendant. The possibility is, and now coming to when is probate required, I should here probably invite your attention to two particular sections of the Indian Succession Act. Section 57 of the Indian Succession Act and Section 213 of the Indian Succession Act are very important. The Section 213 of the Indian Succession Act lays down that no right as an executor or an administrator can be put before a court of law unless probate or letters of administration is granted of that particular will. So therefore, Section 213. Section 213 is made subject to Section 57. Section 57 mandates probate in cases of, in two scenarios. It is compulsory to obtain a probate in two scenarios. Scenario number one, the properties are situated within the jurisdiction, territorial jurisdiction of the courts of Madras, Bombay and Calcutta. These three courts are called the presidency courts because they were set up by the British government, and they were important courts for the British government because it was easy access. Courts were available in all these three cities. They were close to the sea. Therefore, they set up three chartered high courts in Bombay, Madras and Calcutta. So Section 57 says, if the properties are situated within these territories of Bombay, Madras and Calcutta or West Bengal, it's called the province of West Bengal, which is Calcutta High Court. Now, today it is Calcutta High Court. Either the properties are situated, will may have been written in Delhi, it does not matter. Will may have been written in Chandigarh, doesn't matter. If one of the properties is situated in Madras or Bombay or Calcutta, probate is still required under Section 57. The other scenario is the will is written in Chennai or Madras, Bombay or Calcutta. The properties are in Chandigarh, properties are in Delhi, properties are in Bangalore. But if the person executes the will either in Bombay, Madras or Calcutta, even then probate is required. In all other cases, probate is not compulsory, it is optional. No person is going to go and seek a probate unnecessarily. When it will arise is there is a contest. Suppose a sister files a suit for partition. The brother has a will executed by the father. He is going to say, here the entire property is given to me, you don't have anything. So he can set it up as a defense in the suit for partition. He need not probate because probate is not required where the property is outside the cities of Chennai and the will is also made outside the 3 presidency towns. So therefore, in contentious cases, it may arise even in a partition suit filed by another heir or a legatee who says there is no will. So the person who claims under the will can still prove the will in those proceedings as a defendant. If he succeeds, then the partition suit will be dismissed. These are called contentious proceedings. There is also a provision for revocation of the grant. You apply and get a grant. There has been some fraudulent representation which comes to light later. Or I have given a wrong address of my brother and obtained probate without notice to him, without duly serving him. The brother realizes that later, after the probate is granted to me, then that person has an option to come and say, please revoke the grant, it has been obtained by fraudulent means, or stating something untrue, or the will has become useless or inoperative because of another will. So the brother may say, there is a later will, 2020 the father executed a will, your will is 2019, covers the same properties, therefore my will prevail. So all these circumstances will enable a person to come before the court, knock at the doors of justice and seek for revocation of grant. Because unless the grant is revoked, judgment in rem, the probate being a judgment in rem, the defendant cannot establish his rights anywhere else. So he has to come to the district court or the high court which granted the probate and seek for revocation of the grant. So these are very important. As I told you, the execution, the manner of execution of the will, proof of the will, the burden is always on the person who sets up the will. If suppose the defendant who contests the will says that this is a fraud, the forged will, then the burden shifts. The initial burden is always on the propounder. The propounder has to dispel, as I told you, the factum of death and due execution. Once that is proved, and where the defendant sets up a plea of forgery or undue influence exercised by somebody on the deceased testator, then the burden shifts to the defendant to prove his case of forgery or undue influence. So till then, the burden is always on the propounder. So now coming to nomination. Now this is a brief background of probate and administration. As we have seen, succession certificate, as I told you, is only for movable properties. It is having the same effect as a letter of administration, which is confined to immovable, unmovable, or just immovable properties. So these are the broad aspects with regard to probate and administration and the effect of wills. Now, there's a concept called nomination. What is a nomination? How does it interplay? Does it conflict with the will? Does it conflict with the laws of succession? It's a burning issue. Therefore, let us see what is a nomination. A nomination is a direction by a person to another person to pay something or release some amount after his lifetime to X or Y. It is called a nomination. All of us, nominations are not new to us. We have come across nominations in fixed deposits, in bank accounts, in share certificates, securities, debentures, and also in case of employment, salaries, terminal benefits. We may have to nominate somebody. Life insurance policies, all these require nominations. What is the effect of a nomination? Who can be a nominee? A nominee can be any person, again, over 18 years. The minor also can be a nominee in certain cases, but not in all cases. Any person, preferably a family member. In fact, the life insurance policies, they make it as a mandatory condition that the nominee should be a family member. Whereas for shares or securities, it is not necessary that the nominee should be your family member. It can be a third person also. So these nominations can be made in a variety of investments, mutual funds, shares, securities, bank deposits, etc., etc. And in employment, service employment, where after that the gratuity, the arrears of salary, leave, terminal benefits, all those should be taken by the nominee. So what is the effect of nomination? There is a misconception amongst the public and also amongst young lawyers that nomination is sufficient to vest the property or the asset in the nominee. It is not correct. A nomination does not vest the property in the hands of the nominee after the demise. A nominee is only a custodian or a trustee of the money. He does not become the owner of the asset where he is nominated. He is only a custodian. In fact, I would draw a parallel to an executor. A role of an executor in a will, you can compare it with a nominee in respect of a movable fund, an asset like a fixed deposit or a bank account. Any person can be named as an executor, but he does not become a beneficiary. Just because he is the executor, he does not become a beneficiary. Unless a will says the executor is the beneficiary, he does not become the beneficiary. He is only a custodian for the deceased testator's property. He is given the duty by the testator himself to ensure that the wishes are carried out. So therefore, he is the custodian, trustee of the estate of the deceased. Similarly, a nominee is a custodian, trustee of the estate, movable assets of the deceased. So therefore, the nominee will not become entitled to the money. He is only entitled to receive it and distribute it as per the laws of succession. This is very important. So nomination does not defeat the law of succession. You will have to bear this in mind. Nomination does not defeat the law of succession. In fact, law of succession will override nomination. In law of succession, again, as I told you, it can be testamentary succession, intestate succession. Intestate succession is where a person dies without leaving a testament like a will. Then it is intestate succession. What happens in the case of intestate succession? There is a nomination. In the case of intestate succession, the custom or the local law of the party, suppose he is a Hindu or a Christian, Indian Succession Act will apply for Christians. We are governed by the Hindu Succession Act. The Hindus are governed by Hindu Succession Act. So the legal heirs who are entitled to the estate under the Hindu Succession Act 1956 alone will become the beneficiaries of the estate. The nominee is only a custodian. He will receive the money and hand it over to the ultimate beneficiaries who are the legal heirs. Now, what is the interplay of a will? What happens if there is a will written? Will versus nomination. An executor versus nomination, what is the position? If there is a will written, an executor is appointed, and an executor is directed to distribute the movable properties to X, Y, Z. Maybe legal heirs, may not be legal heirs. But there is a direction with regard to movable properties in the will. One of the movable properties, for example, let us assume, has a nominee. In such cases, if the grant is made in favor of the executor or the administrator, then no other person can represent the estate of the deceased. Section 216 of the Indian Succession Act mandates that when a grant of probate or administration is made, no other person except the executor or the administrator can take charge of the properties of the deceased. Therefore, the nominee is displaced straight away. So the importance is to the will. Suppose the nominee by then had, before the grant of probate, the nominee took the money from the bank or received the money from the insurance company. He is bound to hand it over to the executor. The executor will distribute to the legal heirs as directed by the deceased person. Therefore, nominee, if probably we can call him a postman or a courier agent at best. He does not become the owner. He does not get any proprietary interest or right in the asset. He receives it from the company or the bank, takes it, delivers it like a letter, like a post, delivers it to the legal heirs. That is his role. Here an interesting question may crop up. Then why at all should we nominate somebody? What is the purpose of nomination? See, the person wants to ensure that his hard-earned monies, his assets should be taken by his near and dear or to some particular person whomsoever he wishes. So therefore, he makes a will, or he does not make a will. He wants all his legal heirs to take the properties equally. So the position is the nominee. Why does he appoint a nominee? See, the nominee can be the legal heir. A son or a wife or a daughter can be the nominee. There is no dispute. Nominee can be even a third party. Nominee can be total stranger to the family, but close friend of the person who had invested the money in the bank. So nominee can be a third party, it can be a non-relative, except where in life insurance cases, it has to be a family member. So therefore, nominee can be a third party. Nominee immediately goes to the company, and in view of the nomination already in place, he is entitled to receive the money. So that elaborate procedure of applying for a succession certificate or a legal heirship certificate, it may be very difficult in a number of towns to apply for a certificate from the court. It may be time consuming. So the money will not be immediately made available to the family members. So that is where nomination helps. The nominee can straight away knock at the doors of the company or the bank or the authority and say, I have been nominated. This is a death certificate of Mr. X. Please hand over the money. The company or the bank is bound to honor, because the nomination is made during the lifetime of the holder of the money. The nomination cannot be made after the lifetime. The nomination is made by the person who owns the money, who owns the account, or who owns the security or share. So therefore, the nominee can straight away approach the company or the bank and take the money away. And he steps into the shoes. The nominee steps into the shoes of the company or the bank, and he distributes the monies to the legal heirs. Or if there is a will, he hands it over to the executor, or goes by the directions in the will if there is no executor. So the person named in the will is a person in whom the testator imposes a lot of confidence. So if I don't have confidence in X or Y, I will not be appointing him as executor in my will. Therefore, the comforting factor is a person in whom the deceased person had a lot of confidence, reposed confidence, is in charge of the money straight away. As the nominee, he goes and collects the money from the company or the bank, or the FD is realized, and thereafter it is his duty to discharge the obligations by handing over the money in due proportion as per the laws of succession. Christians are governed by the Indian Succession Act. Muslims are governed by the customary law. We are governed by the Hindu Succession Act. Therefore, as per law, if there is no will, in the absence of will, as per law, the estate will be divided and properties will be, shares or movable assets will be distributed. This is where the nomination comes into play. In fact, the earliest case which went up to the Honorable Supreme Court is 1984, AR 1984 Supreme Court, page 346, in Sarbati Devi versus Usha Devi. The Supreme Court said the nominee is not entitled to appropriate the money. He is only a custodian. He is only a trustee. This is the earliest case in 1984 where there was a conflict where the nominee felt because he was nominated, the money belongs to me. But the court said nothing doing. You are only a trustee, a caretaker. You have to distribute the monies. That is the earliest case. In 2009, 10 Supreme Court cases, page 680. 2009, 10 Supreme Court cases, page 680. In Shipra Sengupta versus Mridul Sengupta, the Honorable Supreme Court said the nominee is only a hand to receive. So nominee is only a hand to receive the money. You cannot pocket it. You will have to receive it and distribute it to the legal heirs. So the principle in 1984 Supreme Court 346 was reiterated in 2009, 10 SEC, page 680. Later, 1 year later, 2010, volume 10 Supreme Court cases, page 671, in Ramchandar Talwar versus Devendra Kumar Talwar and others, the Supreme Court, referring to 45 ZA of the Banking Regulation Act of 1949, again reiterated the principles set out in 1984 by the Supreme Court and said the ratio laid down by the Honorable Supreme Court in 1984 still holds the field. Even if it is a corporate security or a debt, the nominee cannot lay his hands and appropriate the money. He has to distribute it to the legal heirs as per the laws of succession. This was reiterated in 2010. In 2020, as late as last month, July 6, very interesting case went up to the Honorable Supreme Court. It is, I think, not even reported. Probably you had access to law channels or law groups, you would have read the judgment. The Supreme Court in Aruna Oswal versus Pankaj Oswal, rendered on July 6th this year, last month, 2020, just a month ago, where the son went to the NCLT. He also filed a suit for partition. Father died. Father had nominated the mother, that is his wife. Father's the son's mother had been nominated to shares of the company in which the deceased person had held shares and securities. The son, who was not the nominee, went to the civil court and filed a suit for partition. Parallelly, he also approached the NCLT under the Companies Act and complained of oppression and mismanagement. So both these proceedings were going on parallelly. The partition suit was pending. The matter under the NCLT proceedings reached the Honorable Supreme Court. The Honorable Supreme Court, reiterating the fact that a case of a nominee in the event of security under the Companies Act is different. It stands on a totally different footing. It is not like the other cases of bank FDs or LIC policies where the nominee is not entitled to appropriate the money. Under Section 79 of the Companies Act, the nominee is the owner of the asset. He steps into the shoes of the shareholder himself. That is the difference in case of securities. Section 79 is an exception. Section 79(3) of the Companies Act of 2018 says, notwithstanding any other law in force for the time being, or any disposition of any nature, testamentary or otherwise, therefore the Indian Succession is knocked away. Banking Regulation Act is knocked away. What prevails is Section 79 of the Companies Act 2013. So in case of securities alone, it is an exception. It stands apart from regular nomination. If you nominate a person for your shares or debentures, or what we call securities in a company, then the nominee becomes the owner. He is entitled to the shares. He takes predominance. He can probably, I would say, defeat the succession laws and claim proprietary right over the shares and debentures under Companies Act. So that is the marked difference. But still, even though this view was confirmed by the Honorable Supreme Court, they referred to Section 79. The Supreme Court felt because there is a suit for partition and the right of inheritance is at large, it is not proper for a company court to decide. The NCLT is not the proper forum to decide the inheritance issues like these. Probably if the partition suit was not pending, the Supreme Court might have taken recourse to Section 79 and said that the son is not entitled, mother had been nominated to the shares, she is the owner of the shares. But here, because of the peculiar facts, the partition suit filed by the son was pending. The Supreme Court said, you please await the result of the partition suit. And parties will have to work out their rights and establish the nominee, or otherwise the wife who claimed that she is the nominee of the shares must make out a case before the civil court and claim the shares. This is a reasoned judgment of the Honorable Supreme Court. So therefore, as we have seen, if there is a clash between normally nomination and will prevail. The law of succession will prevail. The nomination gets defeated except in cases of securities under Section 79 of the Companies Act. The nomination can be changed during the lifetime. So you may ask me whether I can nominate two persons. Yes, separate companies, they have separate rules. In life insurance policy, you can have one nominee. In mutual funds, up to 3 nominees are permitted. So there are different sets of rules for nomination with regard to different policies or funds. You are entitled to follow, you are entitled to change the nominee. In case of public provident fund, if suppose the holder of the public provident fund is a minor, the account is in the name of the minor, then he cannot have a nominee. Because the person himself a minor. Therefore, there is no question of nominee in a public provident fund where the account itself is in the name of the minor. So therefore, we will have to be very careful, see what are the nominations available before making a nomination. There is another question which is normally asked. I have already invested in a fixed deposit, but I forgot to give nomination. Can I do it? No. Yes, you can. You are well at liberty to approach the bank or the company or the institution and say, I want to make my son as the nominee. I want to make Mr. So-and-so as the nominee. My wife as the nominee. You are well within your rights to include a nominee, even though it was not done at the first instance. You are at liberty to change the nominee. Suppose you may have lost faith in the nominee, or the nominee may have predeceased. So in such cases, you can again go back and say that I want to change the nominee, and you are entitled to change the nominee anytime during your lifetime. And nomination does not follow the same rules of proof of will or execution of wills. Where we saw, we have to prove the will, prove due execution. All these are not relevant. It's very easy. You just fill up the forms. At best, probably an advocate has to attest the form, or notary public. You submit it. the nomination is recorded in the company, and the nominee is entitled to approach on your demise and claim the money. So that is where nomination is very comfortable for the family of the deceased. Now, you will have to again choose your nominee. Be wise and choose the nominee. Therefore, as we see, will or succession defeats nomination. In the case of shares of securities, nomination defeats law of succession. It is vice versa. So overall, if you see, leave alone securities of a company, in all other respects, it is always the loss of succession or the will which will prevail. That is why importance is given to a will. We have seen even the Birla family go up to the Supreme Court because of a will. A will can make or break relations. It's a very important document. Therefore, it is very crucial that will is in place if at all you need one. And in fact, I would like to quote the Privy Council in 1924, AR 1924 Privy Council, page 28, Motibai, Hormus G's case. The Honorable Privy Council went on to hold that a man may act foolishly or even heartlessly, but if he knew what he was doing, he knew the consequences, the court will not interfere. So that is the importance of a will. So therefore, please remember, making a will is very important if you want to defeat the line of succession or make particular bequests. It is not necessary to write a will if you want your family members, the other legal heirs, all the legal heirs who will get the property. Otherwise, the laws of succession gives the property to your wife and children. You want the property to go to the wife and children, there is no necessity to write a will. Will is required only when you want to defeat the law of succession. So as the Privy Council said even in 1924, the courts will respect your last will and testament. Your last wishes will be honored because the will is a solemn document. And I would like to conclude with a very funny quote. You may live your life without a lawyer, but you can't die without a lawyer. Thank you.
Mr. Balaji, the way you have expressed the things, it was mind-blowing. And what you said on the lighter tone, and it is also said that once there is will, the lawyers also leverage. The more amount of wills, the more amount of the lawyers, and the more they do. We will start taking the questions. Can immovable property, this is by Srinivas Mulguri, can immovable properties be given to any other person other than the legal heirs through the will? And if a testator dies before the trial, how to prove the will in such a case?
Before testator dies before?
How to dies before the trial? He
is probably wrong. See, trial commences only after death. Until then, as I told, the will is an ordinary piece of paper. You can definitely give it to Tom, Dick, and Harry. You can give it to your neighbor.
Probably he wants to intend to say that, let's assume somebody challenges that will in that particular case and the witnesses die. Then how do
witnesses dies? Yes, there is a provision. If the witnesses are not available, you are not able to call the witnesses to prove the will. There is a provision under the Succession Act where you will have to call one of the persons acquainted with the testator's signature. You will have to prove two things. Number one, the signature of the testator who executed the will, that the will is in his handwriting. It can be a relative or an employee or an employer who was acquainted with the signature, a bank manager. He can come and say, this is the person who wrote the will, this is the signature I am able to identify. That is one part. Number two, you will have to prove the death of the two witnesses or the non-availability of two witnesses, not found, not traceable in spite of diligent steps. The court must be satisfied that you are unable to procure even one of the witnesses. You will have to examine one witness at least. Not necessarily that you have to bring two witnesses to prove the will. Any one witness can be produced at trial to prove the will. Suppose you are not able to produce even one witness, you must first satisfy the court that you are not able to procure the witnesses or the witnesses are dead. Then the next step is you call one of the persons who is acquainted with the attestar signature. Like how you prove the signature of the testator, you prove the signature of the attestar. One attestar can come and attestar's wife can come and say, this is my husband's signature. That requirement is sufficient to prove the will. And you can definitely give the property to a non-relative. That is the purpose of writing a will. You want to defeat the line of succession. You don't want your family members to take it. You want your friend or probably a cancer institute to take the entire property. You are well within your rights to execute it.
Yash Gupta. If I have nominated X as a nominee after my death for my bank account or mutual funds, but in my will I have nominated Y, then which will prevail in such a
No,
situation?
will prevail. Will supersedes nomination. The will supersede regular nomination. So will definitely prevail.
This is by Ishita Nagpal. What strategy should be adopted while drafting the affidavits of the attesting witnesses? This is quite generalized.
First, basically, if you will have to gather the facts of the case, there may be cases where both the witnesses did not sign on the same day. So you will have to. There is a format in the, as I told you, the three presidency courts of Madras, Bombay, and Calcutta. They have original side rules. See, other courts fall back on the Indian Succession Act. But these three courts, being chartered high courts, they have special original side rules. These rules have specific formats for how affidavits should be filed. So normally, this affidavit format is followed in all probate cases across district courts and also other high courts. What basically is said that you have to satisfy the requirement of due execution. I knew so-and-so person who died. I know that he is no more. I know that he has executed a will because I have attested as one of the witnesses. I saw Mr. X sign the will in my presence and in the presence of attesting witness number 2. Both me and attesting number 2 were present when he signed the will. When we attested the will, the testator was present. He witnessed our attestation. Testator was in sound and disposing state of mind, memory, and understanding at the time of execution of the will. If the affidavit discloses these facts, you are bound to succeed. And the witness withstands cross-examination, you are bound to succeed.
This is by Abhishek Sharma. I will modify further. He says, can the registered will be challenged? If yes, what is the limitation for challenging the same?
See, registration does not give any sanctity. The will anyway has to be proved if there is a contest. If requires probate, definitely you will have to come to court, prove the will. If suppose it is a property which is outside the three presidency towns, does not require probate. But if there is a contest, you have to prove the will. And factum of registration may not give you much mileage. It may be one additional factor which will support your due execution, but it does not dispel with the regular proof of a will. Otherwise, you will still have to examine the witnesses and prove the will. What was the second part of the question?
What is the limitation to challenge that?
Limitation, yes. See, limitation to challenge a grant up to 2008, the view was probate is a continuous cause of action. There is no limitation. That was a view taken by the Madras High Court Division Bench and followed by various courts. But 2008, the Supreme Court said Article 137 will apply. So Article 137 will apply, which means 3 years from the date when the cause of action arises. So that will again be ambulatory. It may be the date of will, it may be the death of the person who wrote the will, it may be date of knowledge of the will brought to light. So it is ambulatory. But Supreme Court says Article 137 will apply to probate proceedings. But the Division Bench of the Madras High Court distinguished and said, we are bound by the original side rules. We don't have a limitation. Our original side rules say you will only have to explain delay if it is not filed within 3 years. So therefore, this will prevail. Being a special set of rules for chartered high courts, the Madras High Court Division Bench distinguished the Supreme Court judgment on facts and on legal position and said there is no limitation insofar as Madras is concerned because we are governed by original side rules. In all other cases, Article 137 will apply. You will have to make out a case to challenge the will and say that I had knowledge of the will only now. So therefore, within that date, 3 years, I am coming to court.
But the law to that effect is also, it will be akin to then the writ jurisdiction which says it cannot be dismissed on the ground of limitation, but it can be dismissed on the ground of laches.
Laches, right. Something very similar. Something very similar. Suppose you had knowledge of the will, but you chose to remain quiet for 5 years. Then 6th year you come to court. You are definitely bound to lose on laches. Yes. Delay may not be put against you, but
because
laches.
Punjab Haryana full bench says, Teja Singh 81 full bench page 1, it says that where limitation does not apply, but still the broader principles of suit will civil proceedings will apply, and therefore invariably the principles of 3 years will apply. Maybe not stricto sensu, Article 137 of the Limitation Act will not apply, but yes, for all these assumptions, because that is the principle. One of the dispute, though out of the context, it says as to whether there will be a limitation for a writ petition. There are petitions which says it has to be within 30 days, but some says that since it is a writ petition, there is no limitation.
So
you just have to explain it on the ground of the laches alone, not on the ground of limitation.
Correct.
This is Is there any time limit to get the probate after the death of the will maker?
This again, same principle, Article 137, 2008 Supreme Court, as I told you, for revocation as well as for applying for probate. Same Article 137, Supreme Court in 2008 has said Article 137 will apply. But when is the question? When does that period start running? Is it the date of death? But Supreme Court left it open. They have not said it will be from the date of death you have to file within 3 years. Supreme Court did not say that. Even in the very same judgment where they said Article 137 will apply, they only said cases may differ on facts. One from the date of death, one from the date of execution of the will, or one from the date of knowledge of the will. The will may be in hiding. It may have been brought to light after 4 years. So 3 years from that day. So it will differ from case to case. But Supreme Court says Article 137 will apply for filing of probates and revocations.
This is by Nazakat. If a person has properties in Mumbai and Kolkata, does he require 2 separate wills and probate petitions have to be initiated? What is the way out?
No, he has an option to, if there is one will, you can either probate it in Mumbai or Calcutta. Not necessary that you must execute 2 wills for this purpose. A single will, consolidated will is always better. So it gives lesser room for confusion and suspicion. So you may, by mistake, include some property in both the wills. If it is exclusively for Calcutta property, you can execute a will in Calcutta. Exclusively in Bombay, you can execute a will, probate both the wills. But one consolidated will is always better because, as I told you, it's the last will and testament. So there is always a chance that some opening is given, which is the last will and testament, that should not be put against. And genuine intentions of the testator defeated. They are advisable to have one consolidated will. You can probate it either in Bombay or Calcutta.
More like a doctrine of election.
Yes. Not forum shopping.
No, I'm saying doctrine of election. It
Yes.
That you have to choose between the two and then
choose.
ultimately go ahead. What is this thing? This is by Anurag Jain. Under what provisions of law legal heir certificate is issued and by whom it is issued?
The legal heirship certificate, it varies from state to state. But I am told in Mumbai there is no such thing as a legal heirship certificate. You will have to get an administration certificate from the court. In Tamil Nadu, we have a legal heirship certificate. The revenue authority, the Tahsildar, is competent to issue a legal heirship certificate. It varies from state to state. It depends on the state legislation.
This is, sir, can relatives, close relatives be your witnesses for will or any other property documented?
For Hindus, there is no bar. For Hindus, the relatives can be witnesses. But insofar as Christian wills, if a beneficiary attests the will or the spouse of the beneficiary attests the will, then that bequest is gone. Insofar as the Christian law under the Succession Act, insofar as for Hindus and Buddhists and Jains, there is no bar. Close relatives can attest, but advisable that the beneficiaries don't attest. So you don't take part in something which is conferring benefit on you. So tomorrow court is likely to throw suspicion on that aspect. Why did you go? Why did you attest? You are the beneficiary. You could have avoided. So to avoid these aspects, better the beneficiary does not attest. With no harm, he can be an attesting witness.
This is the original will has been lost, but you have a photocopy.
Yes.
What are the checks and balances for that?
There is a provision under the Indian Succession Act where if you are able to show the contents of the will is lost, court is still competent to grant probate of a lost will also on the contents. You must show that there is a photocopy or you prove the contents. You don't even have a photocopy. You have a note which is signed by the testator referring to this will. So you are able to prove the contents of the will, court will grant subject to a rider that you will have to produce as and when the will is traced. Till then, it will be limited till then, till you trace the original will. And the court will keep monitoring your actions.
This is by Payal Bharat Kotwani. Testator intends to make a conditional will, making the nephew to give maintenance to his wife. But after her death of the wife, the nephew will be the sole owner. Is it valid? Which makes no ownership to be given to the wife.
See, probably this case there are no children. Suppose the nephew and wife had children. So the wife becomes the beneficiary. Condition is wife has to get the property ultimately. So if wife died, legal heirs of the wife will become entitled to the estate. So not necessarily that the will has to be changed. The legal heirs will step into the wife's shoes and take claim to the property. So if it is only the husband, the nephew alone, he will get the property in entirety.
Test. This is, can executor be the beneficiary?
Yes, executor definitely can be a beneficiary.
I will just check because on the chat box there none. I can just check as to whether there are any questions on the Facebook.
Sure.
Facebook. And I think we will take 2-3 more only. Otherwise, as you at the first blush said that free advice everyone cherishes. I'm reminded that
this is what we've been doing. All webinars, in fact, is free advice. No more free advice.
No, I'm reminded in a lighter way. They said that one of the doctors asked to a lawyer in a marriage. He says that I'm quite worried that people start asking me about the medicines, etc., etc. What should I do? He says, what are your charges? He said, I'm charging 500 rupees per visit charges. So he said, you charge 1,000 rupees because these are the express charges if somebody asks to the advice on this way. So the doctor said, I'm deeply obliged. But the next day he receives 22,000 bill saying that and that I've given you the advice during the marriage. So kindly reimburse that bill also. Just check. But since it is quite elucidated one, I don't think there will be much questions. Yes, this is by Anshu Agarwal Bansal on the Facebook.
Yes.
He says, no, by Amit Patel. Can will declare before death, not for implementation? No, because that is, I can read the question, but at least I've not been able to make it. Can will declare before death, not for implementation, but knowledge about will?
Yes, yes. Legal heirs can be put on notice about the will, no harm. It is the choice of the person who makes the will. If he wants the legal heirs to know that this is how I'm leaving my property, there is no harm. He can definitely do it. He can declare the contents of the will.
If, this is by Subhasini. If the testator writes the will in his own handwriting without his signatures, what will happen in such a case?
It is not a will. So the minimum requirement it may be in the handwriting, but any unprivileged will, minimum of 2 witnesses will have to execute. Even if it is a holograph will, as I told you, in the handwriting of the testator, the requirement of 2 witnesses cannot be dispensed with. It is available only to privileged wills. Person who is in the army or the navy or actually engaged in warfare, he can execute a will in his own handwriting without signing. That is valid. But for unprivileged wills, for a common man like us, it is not valid. It is not a will.
This is the last question we will be taking. What is the procedure to be followed for execution in general?
Procedure to be followed.
Yes.
See, as I told you, it is a very simple document. It's not necessary that you must even take legal advice. You just pen down your wishes. You normally say, you're expected to say, this is my family. You describe your family. You describe your assets and set out the manner in which the assets should be taken by your legal heirs or by a third-party beneficiary, and advisable to give reasons. Tomorrow, when matter is contested, your words in the will are going to be given a lot of weightage by the courts. So if you are going to give reasons why you are not giving X son, why you are giving more to X, Y son, these reasons will be very helpful. So therefore, please give reasons as to why you are making such a bequest. If you are not giving to family, you are giving to charity, why are you doing that? You may be thinking that your children are very well off, they are all abroad, they are not going to come to settle in India. You set out that reason in the will. That will help the ultimate beneficiary get an easy order from the court. Therefore, and ensure that the will is signed by 2 witnesses. Choice of witnesses is very important. See, I have seen number of wills where a person aged 70 years executes a will. He calls his 2 school friends who are all of same age to attest the will. Both the attesting witnesses are no more when the trial happens. You are unable to prove the will. Therefore, choice of witnesses is very important. So not only execution, when you call the witnesses, you ensure that they are of reasonably middle age, who will survive you. In natural course, the attesting witnesses should survive the testator to be alive to speak about the prove genuine execution of the will before the court, if at all a contest arises. Therefore, choice of witnesses is very important, and ensure that the witnesses are signing in your presence, you sign in their presence, and due execution is made. Now that technology is also advancing, I think you should take advantage of the fact that you can videograph execution of a will. This should be, in fact, become a mandatory rule if you ask me. Then number of contests will come down. If the entire process of executing a will is videographed and recorded, either at the house or the lawyer's office or the solicitor's office, the chances of that will being questioned later on the ground of the suspicion or undue influence will definitely fail. Therefore, it is advisable to video record the proceedings when you execute a will. So these are the safeguards which you will have to take. I think that should help you sail through.
Yeah. Thank you for all the inputs. Again, on the lighter vein, we can part before I give a formal vote of thanks. Sure. It is said that a young lawyer goes to his father. He says that the case which you were fighting for good 20 years, I went for the first time and I got it decided. The father says, who was a lawyer, he says that it was only because of this which you could study and become a lawyer. Such cases should not be dealt with so fast. So,
good one.
So your advice that videography, etc., etc. I just got reminded of that particular joke that the lawyers who are listening to you, they will say he's acting adversely to the. That's joke apart.
We will still find a way. We will still find a way to question those wills.
So then I am again reminded. They say that where there is a will, there is a way. So in this case, the will emphasis on that. The other will what you are given the insights. And thank you, Mr. Balaji, for all the insights, what you have given to us. We are actually enamored from the fact that you accepted our invite, and still you have been able to give at a short notice, but you have been able to give us the insights which are quite breathtaking and insightful. And tomorrow, for all the friends who have been connected with us or those who will connect with us, because after all these webinars, we get a lot of people being connected with the webinars. Tomorrow, the session is Defense Strategies in Criminal Cases. That is by Bharat Chugh, a former civil judge and metropolitan magistrate. And those who have been following him on the Instagram and Facebook, they know that his insights are as enriching as whatever the speakers we have brought on this platform. So do stay connected with us. And those who want to connect with us on the previous webinars, you can subscribe to our Beyond Law CLC YouTube channel. And share with your friends also. Thank you, everyone. Stay safe, stay blessed. And once again, Mr. Balaji, the entire team of Beyond Law CLC and the participants, not only on the platform, plus also on the Facebook, are actually indebted the way you gave the insights. And it was a session which will be remembered for all times to come. Thank you.
Thank you. Thank you.